who engaged in certain conduct with people that they knew to be related to them, that conduct was prohibited. It wasn't just biological relationship, though. It was the statute read that even people that were related to one another by marriage, for instance, step nieces and nephews, were considered part of the relationship under the statute. And it's my understanding that in this case, the victim was not biologically related to Mr. Encinas. She was related through marriage to Mr. Encinas.
What we are watching is an administrative hearing that took place in 2021. This attorney is pleading for his client's case to have the right at parole, saying, hey, it wasn't actually incest. She wasn't related to him. So let's watch this administrative hearing and then we'll unpack it at the end.
Certainly, Chairman Roche, thank you for having me. Attorney Andrew Bevinetto on behalf of Mr. Miguel Encinas. We are here today, it's my understanding, for a administrative hearing for the board to determine whether or not Mr. Encinas should be placed on the parole docket to then have a parole hearing where he could be granted parole release. At first blush, I believe Mr. Encinas' case looks like an easy one to decide for you guys. He was convicted of a sex offense years ago, convicted of Louisiana Revised Statute 1478.1, which was entitled aggravated incest at the time. That statute itself was repealed in 2014. While it was a sex offense at the time he was convicted, it does not exist in law in Louisiana anymore. Part of the statute that existed at the time allowed for individuals who engaged in certain conduct with people that they knew to be related to them, that conduct was prohibited. It wasn't just biological relationship, though. It was the statute read that even people that were related to one another by marriage, for instance, step nieces and nephews, were considered part of the relationship under the statute. And it's my understanding that in this case, the victim was not biologically related to Mr. Encinas. She was related through marriage to Mr. Encinas. And not only was she not related biologically, but they did not have a lot of contact with one another before this conduct occurred. So it's not like this individual had grown up, her entire life knowing Mr. Encinas. And that's not to diminish the conduct. It was certainly illegal at the time. I don't think it would be illegal under the law in Louisiana right now. But again, he was convicted of a sex offense, not trying to diminish that in any respect. It is an unusual case, though, because Mr. Encinas, he was convicted years ago. The victim in this matter, though, her name is Miss Bethany Torres, and she has actually been in contact with me. And not only does she not oppose his release on parole, she actually wants it to happen. She believes that he should be released on parole. And that, again, is the victim in this matter. I've spoken with her, and I think it's worth noting that when Mr. Encinas was placed on the parole docket 2 years ago in 2019, he was subsequently kicked off for a write-up, which I'll speak about in a minute. The PPI that was done, they tried to contact her, but they had a bad address on her. So they never got any information from her, whether or not she had opposition or was in support of his release. I've spoken with her. She has told me that she does not want to be a part of the hearing. She said, I've moved on with that. I don't want to be a part of anything going forward, but I am willing to submit an affidavit, saying that, I am in support of his release. I know one of the things that the board always looks at and weighs very heavily in considering these cases is whether or not the offender has had any sex offender treatment. I'm sure from looking at your notes that Mr. Encinas has not. I have been able to do a little bit of an investigation, and according to him, the facility that he's been at for the last 3 years did not offer any sex offender treatment until about 30 days ago. That's according to him. I have spoken with Dr. Brandon Romano, who is a specialist dealing with the psychosexual risk, evaluations. And Dr. Romano has sent me a letter that I will include in my mitigation packet to the parole board if he's granted a hearing, that states that upon immediate release, if he is granted parole, Dr. Romano will do a comprehensive psychosexual risk assessment on him, and will order that he follow up with any treatment and any all clinical recommendations for psychotherapeutic treatment and any other services that that Dr. Romano thinks that Mr. Encinas might need. So I do understand that the board is always giving great weight to whether or not the offender has had any of that treatment inside. I think that according to Mr. Encinas, it hadn't been offered to him. And I think that, if the board grants that he, be allowed to get put on the docket for a hearing, we can have that letter from Dr. Romano that shows it can be made a special condition of his release. You immediately go, within a week of release, go report to Dr. Romano's office, get evaluated, and follow any recommended treatment. Mr. Encinas has employment lined up. He has a job waiting for him at Kellogg Construction and Painting. I've spoken with the owner of that company numerous times. She's very supportive of Mr. Encinas' release and says he will have full-time employment upon release. His last write-up, which was the reason that he was kicked off the parole docket back in 2019. He's been parole eligible for a while, but again, got kicked off because of that write-up. I think it was for something as simple as he was in lockdown and they told him, you're done with lockdown. You need to go back to the dorm. And there was some sort of, issue that he had, and he did not want to go back to the dorm. So he refused to go back to the dorm. And that resulted in the write-up, which got him kicked off the parole docket back in 2019. The programs that he's received, not numerous. He has completed the AANA program that he was offered. He's also completed Cage Your Rage. I'll note that in personal correspondence to me, he's told me that he has tried to apply for other programs, but was denied due to the nature of his charge. So again, I don't want to take up too much of the board's time, other than to say, I do understand why there would be some concerns for, putting him back on the parole docket, but I would ask that the committee, grant him the ability to at least be put back on the parole docket and allow, some of these issues to be kind of fleshed out at a full-blown parole hearing. Like I said, at first blush, it kind of looks like one where, it'd be easy to say, sorry, too bad. But when you really get into it, especially, I think the biggest thing that he has going for him is the support of the victim in the matter. So I will submit with that, and thank you for your time.
Thank you, Counselor. Very comprehensive, and we appreciate the additional information that you gave us this morning. Are there any questions for the attorney? Are we ready to vote? Ms. Renaza?
Yes, sir. Thank you. My vote, I reviewed the case yesterday, and I already had decided I was going to vote for him to grant him a hearing. He's been write-up free since his last hearing. Well, since 2019, I guess. And I'm glad to hear, though, that he's been offered sex offender treatment where he's at. He's in Franklin, right? Is that where he is?
That's correct.
Yeah.
But according to him,
and he does score out as a low risk. So I'm willing to give him a hearing. So my vote today is to grant him a hearing.
Thank you, Ms. Renaza. Mr. Jim Wise?
Yes, sir. I sat on this case, myself and Mr. Roche sat on this case back in 2017 when he was denied. He's been down a long time, and I think he's headed in the right direction. This is by far something to just turn him loose, but it's the deal is that he needs to go and start getting some sex offender programs before he comes back before the board itself. But today I'm going to vote to grant, and he'd be working on some programs.
Thank you, Mr. Wise. Counselor, I have some serious concerns, and one of them was the sex offender treatment. I've been sitting on the board for 5.5 years, and I always like to see an offender take advantage of that sex offender treatment. And before I docketed him, I like to see him start that treatment. Mr. Encinas has a 9th grade education. He's been incarcerated for 7-8 years. He's not started working on the GED program. We have that program at many institutions, and I'd like to see him start working on that GED program. Also, he has opposition from the legal community, and I'm going to deny the request this morning. So he has 2 votes to grant, 1 to deny. Mr. Encinas will be docketed as soon as the paperwork can be completed and he gets into the regular rotation at his present institution. So he will be docketed and granted a parole hearing.
Thank you very much to the board. I appreciate your time, and I look forward to advocating for Mr. Encinas at his hearing. Thank you very much.
Thank you, sir.
Mr. O'Shea to save the day. I think he has a unique sixth sense that can pick up on what's actually going on in a scenario. Miss Renatza and even Jim Wise and said, sure, you know what? Why not let's grant him the opportunity? While Mr. O'Shea said, no, he needs to do this. He needs to do that. And he was denied because he didn't have a GED. And fast forward, thank you, Richard, for sharing the info. Remember, this hearing took place in 2021. Fast forward to March 29, 2024. He's still locked up, and he has not put in any effort to do the small little things that was required of him to do to get this parole hearing. So if you can just imagine what type of roach he is, and to think what could have happened otherwise. Now, also to imagine that legislation in Louisiana, that there are people passing legislation to benefit the roach, to benefit the father that does this to his stepchild. They say, you know what, the language it's too harsh. You know, incest, it's too harsh. It's not biological. Let's lobby to change the law so that the sentence isn't too severe. We see laws like that getting passed in Louisiana, but we don't, instead of fighting on behalf of the victims. That's insane. But yeah, that's what happened in this case. I don't know exactly how long his sentence was, if he had a life sentence for what he did, and then it was commuted. And you know what happened, though, is that he was initially, so his sentence was commuted, what Richard showed. He was given an opportunity at parole, which is what they were talking about here. He got a write-up, so he lost his chance at parole. And that's his attorney brought up, oh, it was a simple write-up. And now, you know, they're talking, hey, get him another chance at parole. And it's like, well, you got to first do these things, which he didn't even do because he likes to be in prison, I guess. But here it is. This is the revised statute, right? Incest is the marriage to or sexual intercourse with any ascendant or descendant, brother or sister, uncle, niece, aunt, nephew, with knowledge of the relationship. Relationship must be consanguinity, but it is immaterial whether the parties to the act are related to one another by whole or half blood. This section shall not apply where one at resident of this state at the time of celebration of his marriage shall have contracted marriage lawful, blah, blah, blah. Whoever commits incest where the crime is between an ascendant or descendant or between a brother and sister shall be imprisoned at hard labor for not more than 15 years. Yes. You read that. I read that correctly. Not for not less than 15 years, but not more than 15 years. Why that would be written into the letter of the law that would restrict a judge from giving more than 15 years. who commits this crime to their own child is insane. Whoever commits incest where the crime is between an uncle or a niece, or an aunt or a nephew, shall be fined not more than $1,000, because God forbid you fine them $1,001, or imprisoned with or without hard labor for not more than 5 years. I'm not reading this wrong. Someone who does this, an uncle and a niece, or an aunt and a nephew, cannot be sentenced for more than 5 years? What? Am I reading this right? What? I'm confused. Wait, there's a newer version? What's 2022? I don't even know what I'm looking at. I don't think this was what I had intentionally wanted to even research. I think I pulled up the wrong link. I was looking for the revised statute that the attorney referred to. But we digress. How for not more than 5 years? Look, what explanation can anyone have for a law being put into law that an uncle who does that commits incest, which I can imagine can be defined as full sexual assault, why is that a maximum of 5 years? Are we all nuts? Are there pedos running around and legislators? I don't think there's any other. I'm lost here. Maybe I'm reading this wrong. I make these mistakes. So if you want to let me know in the comments section, I'm going to start this one as membership only, just so I can get some help on this, because I'm confused. And with that, I'll let you go.